Good morning, everyone. We are now in session 2 here, the arbitration between DKLS Construction Sdn Bhd and Armed General Insurance Bhd. I am FAKRURRAZI, your arbitrator for today's session. But first, I will give a brief to both parties on what arbitration is really about. So arbitration is one of the alternative dispute resolution that is one of the alternative instead of going to the court. This session can only take place if both parties agree on the terms. Unlike the court proceeding, arbitration is not that strict in terms of terms as well as couple of decorum and demeanor, but still a respectful session is needed. Although I am not a judge, but the decision is binding, especially after the award is given to the High Court to be enforced. Everything in this session is confidential in nature and won't be shared to others until and unless it is needed in the court proceeding, or if both of the parties agree on the particular things, or if that thing is in accordance with Section 41A and 41B of the Arbitration Act 2005. Lastly, an application after getting the award must be made to ask the enforcement from the High Court. Do you guys understand, and may I get the detail of the place of sitting and terms used?
Yes, Mr. Arbitrator.
Right. Now, we'll all pledge the pledge of commence. Before that, I need you guys to swear to speak only the truth.
I swear to speak the truth and nothing but the truth and the truth only.
Alright. I will introduce myself first. I am a certified arbitrator as well as someone fully experienced in the industry. I am the founder of a company called Nagasaki Sdn Bhd. I also graduated from UC and Oxford for law in both Sharia as well as civil matters. So, can both parties introduce yourselves?
Mr. Arbitrator, I am Ms. BINTI as a lawyer for the claimant today.
My name is Datin Maria Ogawa, Datuk anak perempuan orang Palai, wife of Datuk Ko Hattif, as well as one of the representative of the company and that founded my beloved husband, DKLS Construction Sdn Bhd.
So, how about the other party?
Mr. Arbitrator, I'm Joya binti Susapaya as the lawyer for the respondent, Armed General Insurance Bhd.
Yes. And I am Mr. Atan bin Bentan, alias Karupandan, as the representative of the Armed General Insurance.
Alright. So, do both parties agree with me being the arbitrator?
Yes,
Yes, we agree.
I agree.
Alright. May I see the agreement and know the details?
Oh, yeah, sure.
Everything is signed, information is here. Alright. Good. The matter in dispute is a claim under a contractor's all-risk insurance policy regarding a death at the construction site. This proceeding will follow the Arbitration Act 2005 as well as relevant procedure fairness rules as well as the Malaysian law, since both of the parties agreed on it and are nationals of Malaysia. I will now invite the claimant to present their opening statement.
Mr. Arbitrator, I am Ms. Binti as the representative for my client and will be giving an opening statement for DKLS Construction Sdn Bhd. So the claimant purchased a contractor's all-risk insurance policy from the respondent, Armed General Insurance Bhd, for a construction project in Mukim Poltesta Kedah. So the policy covered various risks during the construction period from 15th of October 2009 until 31st of August 2011, and the maintenance period from 1st of September 2011 until 28th of February 2013, whereby an extended maintenance cost (EMC) was included in the policy. Then the theft occurred on 30th of January 2012 during the maintenance period, causing a loss of 222,483 ringgit, and DKLS had a claim, but the respondent rejected it, alleging that the theft was not covered under the EMC. Mr. Arbitrator, so we submit that the policy period of cover includes the maintenance period. Second, that the EMC does not remove coverage encouraged under clause 1 of the policy. And lastly, that the burden of proving a breach of condition 3 lies with the respondent. So we will show that the theft is covered and DKS took all reasonable precautions. We request the tribunal to grant the full indemnity.
Mr. Administrator, they agreed to enter into the contract with us, but later give a illogical argument and try to ride away from the responsibility.
I understand the concern from claimants. However, let me listen to the other side as well first.
Alright, Mr. Administrator. I'm Ms. Joya. So, as the representative of my client, I'm General Insurance. So, we deny the liability based on two key points, which is the first one, the theft occurred during the maintenance period, and the EMC only covers loss arising from maintenance works, not general theft.
Yes.
And then secondly, the claimant breached the policy condition number 3 by failing to take reasonable precautions. The policy clearly distinguished between the constructions risk and maintenance period risk. And furthermore, we will show the site lacked adequate fencing, lighting, and that security was insufficient. Therefore, we respectfully submit that the claimant's claim should be dismissed.
And Mr. Arbitrator, we are not irresponsible company, but the thing must follow the contract and all of the issue should be discussed and disclosed. A self-contributory negligence must be considered here.
I hear you, Mr. Atas.
Thank you, Mr. Arbitrator.
I see. Now, I give the floor to the claimant's counsel to call on witness and also present the evidence, since we already heard the part from both parties.
Thank you, Mr. Arbitrator. So with that, I would like to call our witness, Miss. Please state your name and your role in this matter.
Alright, hi everyone. So, my name is BINTI and I serve as the site manager for the DKLS construction in Sdn Bhd.
Okay, thank you, Ms. Haila. So my first question, were there any security arrangement at the site during the maintenance period?
Yes, of course they were. The developer hired 4 guards and we keep the attendance records and proof of the payment to them on a regular basis.
And were lighting and fencing provided at the site?
Yes, of course. We installed lighting and the site was fenced off to prevent the unauthorized access.
Thank you, Ms. Haila. So I think that will conclude my examination in chief from our side.
Thank you, claimant's counsel. Respondent counsel, you may now proceed with your cross-examination if you wish.
Alright, thank you, Mr. Arbitrator. So, Ms. Hailam, let me begin by asking.
Okay, sure.
On the night of the theft, were the guards actually present on the site?
No, right.
Hey, calm down. Hang on. Let me ask you first. Thank you, Miss Arbitrator. And what was your name? No, Mr. Sportman. Okay, so at first, yes, as far as I know, there were 2 guards. There were 2 guards on shift at night.
As far as you know.
Yes, as far as I know, because I am the site manager, of course I know everything. Yes, I know.
Alright, were you able to confirm that they were actually patrolling the site?
Yes, for sure. Of course, you can count on me as according to this book. Hang on, let me check first.
Okay.
Yes, there were 2 guards, but to be transparent, I was not personally there at the time. But this is according to the book because we have the record.
Okay, I understand. Now, considering everything you've mentioned, the guards, the fencing, the lighting, the theft still occurred, right?
It cannot be denied. Yes, it's true. Despite our efforts, the theft still happened. But I can assure you that we took all the precautions that we genuinely believe that were appropriate for the site at that time.
Okay, thank you, Ms. Hailam. So, Mr. Arbitrator, I think there is no further questions on our behalf.
That's it. Thank you. Respondents Council, do you wish to call any witness for your side?
Yes, Mr. Arbitrator. The respondent now calls our witness who was engaged as the insurance investigator for this claim. Ms. Kailan, could you please state your name and your role in this record?
Okay. So my name is Siti Kailan binti Sardin, appointed as the independent insurance investigator by the Armed General Insurance to assess the circumstances surrounding the theft incident reported by the DKLS.
Okay. Could you briefly explain your findings during the site inspection?
Okay, so when I visit the site 2 days after the incident, I see that there was a fence and lighting, but the fence was actually damaged and incomplete, and the lighting was inadequate. So during my visit also, there is no guard, and also there is no CCTV system at the place. I also did not find any immediate documentation to see that there was an active monitoring at that time.
So in your professional opinion, did DKLS take sufficient steps to prevent the theft?
Obviously, no. They should check first, I think. And the measure that I did was actually below the industry standard, particularly during the no-risk maintenance period.
Alright, thank you, Ms. Kailan. So, no further questions.
How peculiar. Two different arguments. Alright, before I proceed to closing arguments, I have a few clarifying questions for both counsels. Counsel for the claimant. Can you point to the specific wording, clause 1, policy that supports coverage for this incident?
Yes, Mr. Arbitrator. So the policy refers to the period of cover, which includes both the construction and maintenance periods. That is not expressly excluded, and there is no language limiting clause 1 only to the construction phase.
Now, counsel for the respondent, were you able to prove that DKLS was reckless in maintaining this security?
Mr. Arbitrator, we submit that the DKLS was at least negligent given the poor fencing, lack of lighting, and unverified guard presence. While we acknowledge the burden lies with us, we maintain that the EMC is limited in scope and does not cover general theft.
Yes.
Understood. Thank you, counsel. Now, how peculiar. Both parties you gave your arguments on different situations. I want an evidence and recording of the site to be given. Does the claimant or the respondent have that?
We did not have that.
Here, Mr. Arbitrator. Yeah. We forgot to give it before this. Here we include the current satellite photo from Google Maps on the site, as well as the recording from our investigator.
Okay.
No evidence, cannot be.
I can see that the evidence shows the non-existence of the fence, as well as the guard and not lighting.
Exactly.
We will now proceed with closing submissions. Claimant's counsel, you may go first.
Thank you, Mr. Arbitrator. So, we respectfully submit the following. The theft occurred during a valid period of coverage. Second, the EMC was intended to extend, not limit, the base policy. Lastly, the respondent has not proven recklessness or a clear breach of condition number 3. Therefore, DKLS acted in good faith and implemented reasonable security measures. We therefore request that the tribunal grant the claimant full indemnity.
Thank you, counsel. Responding counsel, your closing please.
Thank you, Mr. Arbitrator. So our position remains that the extended maintenance clause does not include general theft.
Yes.
The claimant originally relied on the EMC but has now shifted to clause 1, which is procedurally improper.
Exactly.
And the last one, security at the site was clearly inadequate. So
Yes.
therefore, we ask the tribunal we ask that the tribunal dismiss the claim in its entirety.
Thank you, both counsel. Having considered the arguments, testimonies, and the presented from both parties, the tribunal is now ready to render its decision. Listen well, all of the party.
Okay.
First, the theft occurred during the maintenance period after taking the consideration of contra-profferental rule. Secondly, the extended maintenance clause does not cover that, but you see, the time. However, the respondent did not prove recklessness or a breach of condition number 3. While the claimant raised new arguments based on clause 1, which were not fully developed at the initial stage, the tribunal finds that policy, language, as well as procedural context weighs against allowing this shift in argument. Therefore, we can simply say that tribunal's rules in favor of the respondent and the claim is dismissed. Please bear the application to the High Court.
Thank you, Mr. Arbitrator.